Yeah, I'll try to sort of hurry through this, but the two principal limitations on commissions in the UCMJ are found in 821 and 836. 821 is essentially a jurisdictional statute, and it preserves whatever sort of common law, historical jurisdiction existed for military commissions prior to the enactment of this statute. And there's two principal limitations: that you can only try an offender or offense against the laws of war in a military commission. So if the person you're charging is not an offender against the laws of war, or if you are charging him with an offense that is not a violation of the laws of war, then you've exceeded whatever authority Congress has given you, and your commission is unlawful. And we contended that, in fact, both of these limitations had been violated in significant ways in our case. The first is, as David mentioned, Mr. Hamdan was charged with a sort of a very vague conspiracy allegation, totally unrelated to any conduct that might have occurred during military hostilities in Afghanistan. Basically, he conspired to be part of Al-Qaeda, and Al-Qaeda conspired to do a lot of bad things to America. And that was sort of the basis of the conspiracy charge. The other thing is whether or not he's an offender against the laws of war, and that goes to his status under international law and the laws of war. Joe will talk about this in more detail, but basically we say under the Geneva Conventions he's given presumptive POW status, and until such time as he's determined otherwise, he's entitled under international law to be court-martialed, i.e. to be tried in the same courts that our military members would be tried in. The second limitation is in Section 836, and 836 is a limitation on the rules that the President can make for commissions. What 836 says is, with respect to commissions, court-martials, provost courts, all military courts, the President can prescribe regulations, but they cannot be contrary to or inconsistent with this chapter, i.e. the UCMJ. The UCMJ contains about 50 very, very basic, very, very fundamental procedural rules. They provide for things like an attorney, the ability for the accused to attend his own trial. They prohibit him or her from being tried and convicted solely on the basis of hearsay evidence. The President felt that this was not a limitation on his authority to prescribe rules, and in fact the rules for this commission, while Mr. Hamdan was provided with counsel obviously, violated all those things. The rules allowed for him to be excluded from his own trial, which is in contravention of a separate provision of the UCMJ, Section 839. There was no meaningful appellate review in this commission. Essentially, the case file gets tendered to Donald Rumsfeld, quite literally, and he decides whether or not the commission did what he told them to do. And we had a fair sense of what the outcome of any kind of review that was comprised of that would end up. And beyond that, as I said, Mr. Hamdan wasn't allowed to be at his own trial. If the government intended to introduce what it characterized as protected information, Hamdan could be excluded. And in fact, in the 24 to 48 hours that his commission actually was going forward, that exact thing happened. He was kicked out of his own trial, not allowed to confer later with his counsel about what happened. So these we consider to be very, very significant and important variations from these limitations that Congress had placed.